It's Entertainment Law Asked and Answered live. I'm Gordon Firemark, and I am excited to be here with you. So, well, let's see if I can get the camera. There's the camera. Hello, everybody. I am Gordon Firemark, and this is your chance to ask me your questions. I'm going to vamp just a little bit here to wait for folks to arrive on the call and see what kind of questions we might have coming in. I have a couple of questions from the email form, the message form on the website. If you have questions that you would like to ask me in the future, and you are watching this on the replay or whatever, you can head on over to firemark.com/questions and submit them in writing so I can address them. I love it when you're here live and I can answer them for you in person. That is my favorite thing, and I like to answer. It's kind of a fun exercise for me to be confronted with a question and formulate the answer in real time, live on video. So I'm in a different place than usual. As you can see, I'm in a hotel room in Washington, D.C., where I'm attending the Podcast Movement Conference for 2024. And I'll be speaking tomorrow on the subject of the legal stuff that happens in the live, well, not just live, but in video podcasting. And this very live stream thing is an exact example of the kind of thing that we have to think about. There are no takesy-backsies when you're doing live video, and that is a valid legal concern, as well as a handful of others. I don't think I'm breaking any of my own rules here with showing you the sea. Oh, excuse me. And because I'm on the East Coast, it's a little later in the evening, and somehow in the course of 36 hours or so, I've changed time zones. So, my body clock is ready for bed pretty soon. Still have to rehearse my talk for tomorrow before I call it a night. And yeah, well, it doesn't look like anybody's popped into the call just yet, so I'm going to go ahead and start by answering a couple of questions I've received through the website. Again, the address for the website is firemark.com/questions, and I'd be delighted to answer those again, any questions you submit there on a future episode. But let's get started right now after I give you the opener. And, well, as the disclaimer says, basically, I am a lawyer. I'm here to answer questions. I'm not your lawyer, so you're relying on my answers is something that you want to think hard about. Probably not a good idea unless I'm just confirming something that you already believe and know to be true. But if you need legal advice, if you are in need of help with something that a lawyer would do, I urge you to contact a lawyer, either myself or someone else like me, who will be then your lawyer with an obligation and duty to look after your interests and to make sure that things are right. I obviously am not doing legal research during these calls, so if you ask a question and I give you an answer, it is an unresearched answer, usually based on my experience, knowledge, and my background and things. So let's get to some questions here. Let me just, a couple of people have joined. Hi, Tammy. Nice to see you. Welcome. If you have a question for me, go ahead and drop it in the comments. And if not, that's okay too. It is nice to hear from you. So I'm going to get to the first of the questions I have here from the form on firemark.com/questions. This person wrote in and said, I wanted to touch base, a bit of news, because I think last time I talked to you, I reported or mentioned this Disney situation where a woman who had passed away after being exposed to food allergens while at the Disney theme park had been the motion had been made by Disney to force this case into arbitration. Essentially, Disney was arguing that when this family signed up for the Disney Plus service, they waived all the right to sue over any case involving Disney as a defendant. And they have now backed down from that sort of preposterous claim. I think the lawyer who was representing them was being a little overzealous and probably, just a hair, unethical about it, or at least unreasonable in the approach. And to their credit, Disney decided that the backlash and the PR nightmare that had come about from it was just not worth it. And they are, I guess, willing to proceed in court if that's what it takes. So we wish that family the best. So sorry for their loss of a loved one who herself was a physician. She knew she needed to be careful. She knew what anaphylactic shock could look like for someone in her family, and she even had an EpiPen that she administered to herself after she realized she'd been exposed to, I think it was a peanut allergy. So we need to, be more careful. People, everybody needs to be more careful. In any event, first question that I have here in the form is, I just want to know, this person says, from a legal standpoint, if it's fine if I use my movie title that is the same as a short that was released on YouTube 2 years ago in another country. That other film has almost no recognition, and my story is quite different. The only similarity is that it involves a particular kind of food delivery in the scene. I didn't even know of its existence until almost the end of my production, this writer says, in which case I've already promoted my film under this same title. I just want to make sure I don't face any cease and desist over my film. Well, there is no short answer. You're talking to a lawyer. There's no such thing as a short answer. But the first part of the answer, I will say, is that a title of a film is not something that can be copyrighted. So there's no copyright claim there, unless it's a very lengthy title. But sure, generally it needs to be a fairly lengthy original bit of authorship to be entitled to copyright protection. But under some circumstances, we might be talking about trademark law. But that really would only apply if there is a series of films or television programs or something under this title. Because the trademark law generally is not allowed to register, the government is not allowed to register a trademark for a title of a single work. This is the U.S. law, I should say. I don't know what that other country's law on the subject would be, but I suspect it would be similar. It needs to be a line of goods or services. So titles of a single work are not trademark protected. There's nothing necessarily illegal or improper about having multiple works of art with the same title, and that goes for films as well as other kinds of art. However, we might have a potential claim for something called unfair competition, at least again under U.S. law. How likely it is a big question. The premise of that kind of a claim would be that somehow you are passing off your work as theirs, or their work as yours, or something like that. And really depends on whether audiences would be, or would likely be, misled into believing somehow that they were coming from the same source. But in order to bring that kind of a case, or any kind of a case really, the other parties, whoever it is that claims ownership of that other film, would have to come to your home where you are, your home country and jurisdiction, to bring the lawsuit. And so we're weighing the likelihood that they would be willing to do something like that over a title of an under-recognized short film in another country. And here's the thing, though. The writer asks, I just want to make sure I don't face any cease and desist over my film. Well, anyone can write a cease and desist letter at any time. It's just a letter. It does not carry any force of law itself. It's a demand that you stop doing something. And anybody can write that. Anybody can have their lawyer write that. And many lawyers are quite willing to write those kinds of things, even when there's not much of a case. So can you be completely assured that you won't receive anything like that? No, you cannot. Um, can you be assured that you won't get sued? No. Anyone can sue anyone over almost anything, almost any time. So, again, it's a question of likelihoods and probabilities, and that's that. But you can really never be totally safe. But as a practical matter, if you think there's any chance that the source of the material, there could be confusion in the minds of the public, the consumers of this film, it makes sense to just try harder to come up with an alternate title. And yeah, you've invested some time and energy in promoting the film. Um, these things happen, and it is possible to change the title of the film. And that's not a bad idea. And oftentimes, in situations where I've encountered something like this, it's actually turned out that the new title was better. After the parent got used to the idea that a new title was necessary, they came up with something as good or better. So that's my kind of issue. Even though it's pretty unlikely that it'll ever be a problem, um, dodge the problem if you can, I guess. That's the conservative, cautious approach. If it has to be this title because it's sort of built into the story and the plot and the dialogue and all that, then yeah, you're kind of stuck, and you take your chances. And I think your chances are pretty good in a situation like this. But there you have it. Next question that I have. If anybody has a question, they're free to put into the comments of the video wherever you're watching. And thank you for being here. Looks like I have a few people watching, which is great. Welcome. In the meantime, I'll answer another question. This is from a person who says, I am a disabled actor, and I was recently in a film, and they give the title, along with Academy Award winning, Golden Globe winning, prize winning, award winning actor, who I'm not going to name. The executive producer of the film and I recently had a falling out. Everyone was asked, so this person already has shot the film. Everybody was asked, basically, and told that they needed to contribute to marketing the film. And of course, the name of this award-winning actor was the best person to focus on to do so. But apparently, and this actor did in fact do that, but apparently the EP is angry that the marketing didn't also mention and promote the EP's daughter, who was also in the film. Now, okay, should we do films where the children of the people behind the film are also appearing in it, and we get familial relationships that can cloud judgments a lot, and so I always sort of have to take an extra breath when I hear that someone's going to put their kid in a film, or their spouse, or their girlfriend, or something like that. But it is what it is. So the writer says, this EP consistently overstepped our working relationship, and now the film is currently on Amazon Prime. Now, prior to this disagreement, she says, I assume it's a she, I was second in the credits on the trailer, and now I've been dropped to lower on the credits list. That's kind of interesting. Although that goes from trailer to the film, so there may have been other reasons for it. When I viewed the information on Amazon Prime, however, I found I'm not even listed. So the credit for this person was removed from the film. All right. The EP has also smeared my name, admittedly, with another director who was going to use me in a film based off my disability. And I even created the character concept as requested and so on. We also agreed to a back-end credit position as payment option. Now I worry I won't see a dime given this executive producer's actions. So that's the basics. What are my thoughts? Well, my thoughts are, what does your contract say? If your contract calls for you to receive credit, then you are to receive credit. If there's an implied contract that suggests you should receive credit, and I think it probably is, that's something to think about as well. The way if you're hearing that alert, it's telling me that my camera battery is going to die very shortly, so we may be signing off early. In any event, so the contract is the issue. What does the contract say? Well, what if you don't have a contract? In that response, my first response is shame on you both. There should have been a contract. Don't do work for people without a clear articulation of what the deal terms are. But if that's the case, so be it. The custom and practice in the film industry and the entertainment industry is that credit is to be given for performances, and that it should not be removed. Certainly not out of some sort of malice or animus. That removal is a kind of wrongdoing that is probably actionable as a breach of contract, even if it's an implied contract, because there's no written document, and that's the thing. So if there's no written contract for the employment and there's no union, you're not a member of SAG-AFTRA or something, then you might be in a position to withdraw and revoke the consent for the distribution of the film without proper credit. It's similar to that unfair competition, misleading people as to the nature of the relationship. So you might have a little ammunition. It might be worth bringing in a lawyer to do some saber rattling and write that letter, and encourage the other party to do the right thing. Is it worth it? I don't know. You weren't paid cash, I presume, for the film, and so on. So if so that's my point about that. Now, as far as this other film that you were no longer cast in because of some alleged wrongdoing, if that other director will testify that the decision not to use you came after or as a result of something that the EP said about you or whatever, then you might be in a position to sue for defamation, libel, or slander if those statements were false. If it's just an expression of opinion, I don't think she's very good, or I don't think you can trust, those kinds of things, and there wasn't a lot of fact behind it, maybe not. People are entitled to express their opinions, and other people are entitled to base their decisions on what they hear from other people. But if it's false, then be careful, and you could possibly sue for libel. You might also have a claim against the director of the second film that has now excluded you, if you can prove that there was an agreement to hire you for the film, and then it was sort of terminated, withdrawn, breached, or something like that. But it's very fact specific. So I guess what I would say to you, I'm going to just use your first initial R. You should talk to a lawyer. This is not something that you want to get your legal advice over the internet. So you can reach out to me or someone like me, and get some input over that kind of thing. So, certain expenditures. I am on the road. I'm at the Podcast Movement Conference in Washington, D.C. this week, and I actually skipped a party so I could come and do this. I wasn't going to go to the party anyway, but there you go. And I'm excited to be here. I'm speaking tomorrow. I'm giving a talk on the subject of legal issues that video podcasters encounter that audio podcasters have generally not had to think about. And I'll be giving that talk tomorrow afternoon, and then I'm going to enjoy the rest of the time doing another Q&A session there as well. And that's what's going on. So with all of that, if nobody has any questions in the chat, I've got another minute or two of battery life on my phone probably. So ask away. Otherwise, I will say thanks for being here. And if you have a question you'd like to submit for next time, maybe you're watching on, hi Bree, I'll get to your question. Maybe you're watching on a replay or something like that. Feel free to head on over to firemark.com/questions. Bree asks, what sort of legal agreement should I be requesting to do voiceover for podcast and commercials, even if no money is involved? Well, Bree, let me tell you, no money involved doesn't change the fact that you're offering some value, and there it is. Yeah, you're offering value, so they should be compensating you somehow. Maybe it's the exposure. If they're going to give you credit, there still needs to be articulation of what's the bargain, what's the benefit of the bargain for both sides. And that agreement for a voice actor would be a voice actor's agreement or just an actor's agreement. The fact that you're not appearing on camera or on screen is not doesn't change the fact that you're doing a performance, and it needs to address it. It doesn't have to be extensive. Relatively simple deal memo. Dear so and so, we've agreed to X, Y, Z, and so on. You just want to make sure it covers all the bases. And actually, I do have I think I have a voice actor agreement either at podcastlawforms.com or at easylegaltemplates.com. So head on over there and check it out. I think I've got something, a voiceover artist agreement or something, and that should work. If you're just appearing as a guest on a podcast, then a guest release is the appropriate way to do it. But yeah, my mantra that I want you to understand is always get it in writing. Would you include length of time for use? Again, it's a contract. It depends on what the agreement is. If they're hiring you to do or asking you to do a voiceover for a film, for example, nobody wants them to be, after 5 years, to have to pull the film off the web or stop distributing it. Bear with me, it looks like the camera may have died, so I'm going to switch back to, let's see if I can make that happen. My FaceTime camera, there it is. The FaceTime camera is on. Yeah, so your contract, Bree, would need to probably say that that your material is available for use in any and all media now known or hereafter devised, and that would just go on indefinitely. If you want there to be a term of the agreement, then certainly negotiate that into the deal. And if they, you could say you can use it for free for a year, and then after a year, if you want to continue, you'll need to give me a payment or a share of the revenues, or a royalty or something. There's always ways to make that happen. The point is, if it's in writing, you can enforce it. If it's not, it gets a lot harder, a lot quicker. So, yeah, that's about it. So I think that's all the time I have today. I appreciate you, Bree. I appreciate you, Tammy, for being here. Thank you for your kind words. And I'm going to sign off and say thanks for being here. Again, feel free to submit your questions by going to firemark.com/questions. And I have to switch back over here, sorry. And we'll get your answers into the show for next time. Until next time, I'm Gordon Firemark, and I'll see you next Tuesday evening. Thanks for being with me.